I'd like to call our next speaker, Mr. Rohit Girdhar, National Head Fathers Right Wing of Safe Indian Family Foundation. Wonderful. Everybody, let's have a huge round of applause for the honorable gentleman present here. I would request Vishalji to please welcome the honorable gentleman here, Mr. Rohit Girdharji.
Hello.
Everybody, come on, let's have a huge round of applause. Come on. Please take a seat, sir. Thank you. Next, I would like to call on stage Mr. Nikhil. Gentleman here for embarking his presence here. Stage. Our next speaker, Mr. Joginder Singh Jogi, President, Punjab Youth Club Organization, to please come and do us. Thank you so much, sir, for your presence and for doing us the honors of coming here. I would request Vishalji to honor him again. Thank you, sir. Thank you.
Hello.
Has appeared in various TV debates and programs voicing concerns of men. Thank you, ma'am. Thank you for your presence here. I would request Mr. Vishal Kapoorji to please welcome her as one of the members of the panel discussion board here. Thank you so much for your presence, ma'am. Well, it is truly our honor to have all the S.N.Dhingra here, who's going to enlighten us with his epitome of knowledge here. Thank you so much.
Good afternoon, and the organizers. See, this conference is about law reforms. But after going through the names of speakers and topics, I consider that main concern of the organizers has been gender bias and discrimination being faced by men in the courts. Law reforms is a very wider subject, and it has been attracting attention of the nation legislatures since long. But have you ever thought why law reforms do not take place in India despite legislature passing laws? The manner in which our courts function remains the same. See, prior to 1970s, there was a very hot debate in this country about our slow judicial system and about the archaic laws which were continuing from the days of when we were slaves. Our CPC was of 1878. CRPC was of also almost same year. So after hot debates, the CRPC, that is Code of Criminal Procedure, which governs the trials of criminal cases, was amended in 1971. And CPC, that is Code of Civil Procedure, which was, again, it is a charter of trial of civil cases and other cases other than criminal cases, was amended in 1976. The purpose of amendment of these two laws was to simplify and to quicken the disposal of cases. Simplify the procedure and quicken the disposal of cases. Unfortunately, none of the two goals were achieved. Why they were not achieved? You can have a simple, example of the same in this conference here. This conference was to start at 2. Now, what is the time at now? 3. You see, if a conference which has to last, which is life period is only 4 hours, 2 to 6, is delayed by 25%, and it is not considered something abnormal by any one of you, because you also came trickling. Instead of coming at 2, you came right up to 3. And the organizers also thought 2 is not something serious. So we can have it at our own time. So 25% delay in 4-hour conference. Now you think of if delay of judicial reforms in a nation's life which is infinity, how many years it would be? Hundreds years. So if I take this small example that why we are not serious, this gives you, and a very rudimentary example, but this gives you that we are not serious about anything which we want to do. If we had to be serious, we must stick to the norms which we prescribe for others. But when we prescribe and forget, the reforms don't take place. This is what is happening in our judicial system. See, after all, judicial system is run by whom? By people like you and me, who think it is okay, sab chalta hai. And in 1976 and again in 2001, CPC was amended in 76 to say that no adjournment shall be given by any court on the ground of busyness of advocate. You will hardly find a case in which adjournment is not given on the ground of busyness of the advocate. I was wondering other day when I read a newspaper report that bench of Justice Kehar and 2 more judges called case after case and advocates were not there before the bench. The bench, stood up, Justice Kehar stood up in anger and huff and told the court master that call me when advocates are there. Now, what message it gives? This message, which is simple message given, is that court is not run by judges. Who runs the courts? Advocates. Judges are so helpless. They are so helpless that they cannot run a court, they cannot decide a case unless they are educated by the advocates. Why so? See, the maxim goes that every citizen knows law. If you pretend ignorance of law, that I was not knowing that this was the law, so I committed wrong, this is no excuse. But why ignorance of law is an excuse for judges? If advocates are not appearing, you see, advocates are there to help you